Welcome, my dear audience, to my real estate show. I am so glad that you're here with me today. I have a very special guest that's going to be sharing with us all the ins and outs about real estate probate. He's a dear friend of mine, super, super sharp. He knows his stuff. Al Nicoletti, he's been practicing law here in Florida for several years, and his expertise is probate. So please help me give Al the warmest welcome.
Thank you, Angela. How are you? Thank you for having me.
Absolutely. It's always a pleasure.
Always. And I know the last time we all talked, we went through all the probate stuff, and really, I can't wait to go through that again with you.
Yeah, fabulous. So you are the pro in that department, and I just definitely want to dive into it. I know that it's a common thing that we sometimes hear about, but we don't always know a whole lot about. And, you know, the purpose of this video is to obviously find people that are going through something in their life that this will be applicable to, but also it might be one of those things that you might see this in the future, and this information is going to help you prepare for those circumstances, you know, as they come about. You know, these are things that, you know, if you know, then you're going to know how to handle. But if you've never come across this information before, then you might just not be prepared. So I'm hoping that this will be jam-packed with great value. And I think we'll just go ahead and start from the top. Can you just let us know exactly what is probate?
So the basics in real estate world is somebody dies and they own real estate. And the way that the property is titled when they pass requires there to be a transfer, a formal court process to transfer it from the deceased ownership to the heirs. So it's basically going through this inheritance process of who actually is going to be next on title and who is entitled to the property. And I always break it down for people that way because probate has been that word. They think it's complicated. They think it's cumbersome. They just don't understand the process in the real estate world. And all you're doing is making sure it goes from somebody that died owning the real estate to the heirs.
Okay, and when that happens, there's a couple of different things that could happen depending on how prepared they were for that thing. Whether they had a will or if they didn't. Is that something that plays a part into how you would deal with the sale of that property, whether there was a will or not?
Sure. So there's a misconception that a will avoids probate, and in fact, it does not. The will steers where the inheritance line goes and who gets what according to the will. And you always want to make sure there's an original will, because if there's a copy of the will, it's presumed there was not one, and now you have to prove that the people were there and that they signed it and all of that stuff. But one of the things is that the will tells people where to look, tells the court who's getting what. So the lawyer preparing everything's going, okay, the will said Sally gets the property, Mike gets the bank accounts. It lays out the game plan of where things go. But, you know, the stat out there is that 95% of people do not have wills. So in Florida, when there is no will, the Florida legislature created a pathway of who gets what. And so the pathway is, first you look to see if the spouse has survived. And if there's no spouse, then you look to the children and you go down the descendant line of children, grandchildren, great-grandchildren. And if none of those, then you actually look up. So you go parents, grandparents, great-grandparents, if they're still around, and then you would go out. So then if there's none of those, you go to brothers and sisters. So you're really going down this line of, you know, it's good to plan. You know, if you want to make sure that your brothers and sisters don't get the property, you know, make sure you put your who you want to get it in your will.
Your will together, yeah.
Right, get your estate plan together. But a lot of people just don't do that, and they have to understand when you're trying to get your contracts together for the sale of the property, you're trying to look to see who's down the line, who needs to get on there. That's very important.
Okay, so if you do have a will, you just mentioned that that does not mean that you avoid probate. So where does probate come into play when someone did have a will and made the necessary preparations to decide who gets what?
So the will really just plays the role as the person died, they own the real estate, and now the court and the attorneys representing the estate look to the will to see where it goes. It guides everybody. It doesn't avoid probate because there's only a couple things that can help avoid probate, like the revocable, irrevocable trust, the Lady Bird life estate deed that people create. Maybe they, and let's not be mistaken, if husband and wife are on the deed and husband dies, it goes to wife.
Yeah.
If wife dies, and then you need probate. So there's certain ways title plays a lot into this. So people will think, oh, if husband's the only one on the deed and wife's around and he dies, we do not need to go through probate. That is incorrect. You still have to because she's not on the title. She'll get an interest through the probate, but avoiding probate with husband and wife is making sure in Florida that you both are on the title.
Okay, now would this be on properties that are not homestead? If this is their primary residence and it's their homestead here in Florida, if the husband dies and the wife still alive, would it go to the wife directly, or would probate still take place in a homestead situation?
Correct. In that circumstance, husband's only on the deed and wife's still around, you have to go through probate. And homestead does play a role because in Florida, homestead says this: if the wife is around and there are also children, she has two options. And this is where it gets kind of like in the lawyerish role, but
yeah,
she's got two options. She could take a life estate, meaning she could live there for her life, and upon her death, it goes to the children. Or within 6 months from the date of death, she can elect to take a 50% share and 50% share to the children. Now, that scenario doesn't play out for non-homestead, second, third, fourth properties. It only plays out for the homestead property. But you always want to find out, is the surviving spouse around? Super important, because a lot of the properties you come across or potential listings, they're generally the person's homestead, because for probate, the definition of homestead is not whether they claim the tax exemption. It's where they lived, where they resided, where they intended to occupy. That's the homestead. So you want to make sure you get the right people on the contracts too.
Gotcha. So let's say they do have to go through probate. What is that process like, and what could they do to prepare themselves to successfully go through it?
So one of the first things is, if they do need to go through probate, or they find out somebody says you got to do probate, find the lawyer. Like me, I do probate. You need somebody that's going to help guide the system. In my world, I help figure out, where are we going to go with this? What are we looking at? Are there creditors? The whole thing. But always finding the right lawyer is a great way to go. And then figuring out what everybody wants to do with the property. If they want to sell it, if they just want to put it in their name, a lot of times this can get done, especially in Duval County or a lot of the counties in Florida, relatively quickly. I mean, in Duval, I can get them done in 2 to 4 days. Sometimes it has to be 30 days. But generally, what you're even looking for too, in my world, date of death. If it's been even more than 2 years since the person passed, it's even faster. So people don't have to be worried about how long it's going to really take, because in my world, it doesn't take long. I thump it. So I know how to get those through.
Wow, that's surprising. I think that there's a misconception in the community where most people think that probate is a long, extended, drawn out process. Do you also see that, where like the typical, expectation is for this to drag out tremendously long, and it really isn't?
Yeah, and it's funny. I saw a probate recently we were working on, and we had to jump in on the story where there was the main person. Actually, you know what? I'll show you. There was actually the main person here. She dies, okay, and then there was 1, 2, and 3. Here, let me draw it out better for you. There was 1, 2, and 3, okay, and we found out she dies, and then we had to do a probate for this one. So what did we find out in the probate itself was that the lawyer for the original title holder took 3 years to get a probate done in that courthouse.
Wow.
And we got it done in a week. So yeah, and I don't know what it is. And sometimes I'd like to know from other realtors, other professionals, like, what is it that took so long? Like, we just had a probate litigation case just settle, but it was open for 3 years. And as soon as we got involved, we moved it, we filed the right motions, we got before the judge, and we got to the point where people are either going to get money, the property's going to get sold. I don't know what happens in circumstances where it takes that long. I don't find that in my role unless it's hotly litigated.
Yeah, and one of the things that I wanted to mention is if you're listening to this broadcast live, either on YouTube or Facebook, if there's any questions that you have for Al or myself, please put them in the comments section, and I can easily bring them up to the video so that we can answer them for you. If that's something you would like to do, that's available for you. Obviously, if you're watching me on YouTube, please go ahead and hit the subscribe button, hit the bell for the notifications. I am definitely growing this channel, and I'll love to make you part of it. But definitely the questions, I encourage you guys to ask questions. It's always more dynamic. These interviews are more dynamic when we have participation. So that's fantastic. Now, I do have a question, Al. You mentioned that in that particular case that you were just drawing, the one had to go through probate. What was it about the one that was different from 2 and 3 that made that one go through probate?
Because of dates of death. And I tell people all the time, dates of death matter. And I actually just drew another example. So yeah, there we can see it. So one of the important parts is, so grandma dies in 2015, right? Mm-hmm. When she dies in 2015, we then find out a year and 2 years later, number 1 and 2 die. So the importance is when somebody dies after the main title holder, there is a probate required for title insurance. So you have to make sure that gets done, because technically when she dies, the title gets vested in 1, 2, 3, and 4. Mm-hmm. And so when that happens and somebody dies after, you then need to do a probate for this one, and then you need to do if these people would have died before the main person on title, there is no need for a probate.
Got it.
I always tell people dates of death really matter when it comes to doing probate. And so like in this example, there was somebody that died in 2015. And then after, one of the other sons and the other sons died. And when they died, it required 3 probates, 3 separate ones. And so then you have 3 and 4 that are alive, and then they had children. He had none, so it went to the brothers and sisters. So the important part about dates of death and getting the full story, especially in the realtor world and the investor world, asking the people, you don't need to know the law stuff. But what you do need to know is like the big picture with where things are going, like who's around, what's around, find out, is there anything else that's around? And let me just add something, Angela, that you were saying before, if anybody's got questions, I know there's a lot of people that are going to watch this a week from now, 2 weeks from now. And I hope, when they watch it, they have any questions, or they say, I've been going through a nightmare scenario and I don't know what to do, or, what's causing this, or, I tried to do a probate property years ago and it took forever. Let's share your stories, your nightmares, maybe successes, and just post it. Feel free to, ask Angela. We'll get back together about this. It's important.
Yeah. And one of the things you mentioned, the best way to contact you would be your email. Is that right? It is,
and the phone number. We don't have the website, but we do have the phone number and our email. And my phone number is 904-246-9994. And my email, it's rather lengthy, but I'll still do it anyway. It's A-Nicoletti, so ANICOLETTI at BAPBlaw.com.
I think I got you. Is that the one?
There you go. Yeah, that's cool. Look at that. It's flashing on the
Thank you. I love this. Yeah. Nowadays we can do all kinds of like different graphics and different banners on this. So it's a great way. I'm going to leave that playing there for a minute just in case anyone needs to make note of that.
Sure.
you mentioned something that I think is key for me to know exactly what questions to ask. What this becomes, relevant in my business is when I go into a listing appointment and I find out exactly their motivation for selling. And that drives a whole lot of decisions that have to be made moving forward, depending on urgency. How soon do they need to get the house sold? Whether they've already moved out of the home or they're still living in it. What are some of the questions that I should be asking, or they should be asking themselves, as it relates to probate when you're in the very beginning stages of getting the house sold?
I would still say it goes back to the beginning and getting the best storyline, because when you're finding some of these properties, it ends up being the deceased homestead where they lived and resided. And in order to sell that property, all of those heirs, whether it's in the will, it says who's getting in the will, or down the intestate line, like I went, spouse, children, all of those lines, they all need to be on the contract. So finding the big story is key. Also, working with the right lawyer and being able to structure it in such a way to help them get money at the end. At the end of the day, they're done taking care of the grass that's taller than a giraffe. They're done taking care of the roof that's totally caved in, it's going to fall apart. They're done taking care of a lot of the taxes. I get a lot of these people where there's 1, 2, and 3 heirs, and number 3's been paying the taxes for 20 years. And I'm like, look, let's get this going. Let's figure out how we can move this forward, because you're not going to be able to refi. You're not going to be able to do any loss mitigation or anything at all, sell it without going through this. So I would just say finding out the motivation of, and it's all about money for them. They all want to make the money at the end of the day, and helping figure out how they're going to get money at the closing, or how they can disperse it. I get it all the time. These people they know they're going to make $30,000, $40,000 at the sale. I mean, once you start explaining the whole process about how that's going to happen, a lot of them just come right in.
Now, Al, where this becomes an issue with transferring title, if there's probate, is it a matter of just being able to get title insurance for that property?
Yes, because the old republics, the Alliance, the Fidelities, the Chicago title insurance, they're not going to allow the exchanging of the HUD statement, the keys, buyer, seller, anything at the table of closing until probate's done. And so while the probate's required for the transfer of ownership to the inheritant line, the biggest point in real estate is that a title underwriter insurance company requires this in order for clear insurable title, not marketable, but insurable title, because you're not going to find a title company that's going to look at a quit claim deed going from the deceased or whoever signed it on the deceased behalf to the children. It's just, you cannot quit claim deceased interest of property. So it's a huge underwriting issue to get the probate done.
Got you. And that's always like the grand finale of a real estate transaction, is that closing process, which everyone should understand. When you have a closing, you have a title that's being transferred from the seller to the buyer, obviously. But the way that's done on a real estate transaction is by something called title insurance. And that's what protects the buyer should there be anyone else after the closing that comes in and says, no, well, actually, I have interest in that property. That does belong to me at X amount of percentage, or all of it, or just a small percentage. So that's a key component there to getting that policy, that title insurance policy. So if you have a probate process in the middle of it, that becomes an obstacle to getting title insurance, which will keep it from closing. So it's important to address these things ahead of time, and it's important to know what to ask, who to go to. You mentioned one of the things is going with a lawyer that understands this process. What are some of the things that they should look for in a lawyer to help them walk through the probate process?
One is making sure that the lawyer is motivated to getting it through and getting the property transferred and done. For example, the one I went over, it took 3 years for that lawyer to get a simple order transferred. And I don't know if it has anything to do with billable time. I don't know how to do with a retainer agreement, but finding somebody that's motivated enough to want to help them to get the transfer over, to get the probate closed. I'm motivated, so I understand the side of the lawyer that would say, you need to get this done. This is what has to get done. And then having somebody that's able to structure it in a way that they don't have to pay upfront money. Because in my world, I'm able to just wait until a closing. And
I love that.
Yes, so I can wait until a closing. That means they didn't even have to ever put any money down to get it done. And a lot of the lawyers require upfront money. So we're just unique in that aspect. And finding just the right fit for people. I mean, one lawyer is not going to be the right fit for another person. It just really depends on each lawyer. There's never like a cookie cutter way of saying it.
Gotcha. I like the idea of you getting compensated at closing, and it's something that I am very familiar with because in my line of business, I also do all the work sometimes for months before I get compensated at closing. So I can't think of a higher motivator or a greater incentive for anyone wanting the transaction to be fully closed than working with someone who is going to get their compensation at closing. As opposed to, I've already got compensated, well, let's see if this thing works out. I really think that this is the best way to get yourself surrounded by the people that are in it to win it, to help you attain your goals. Another thing that I always think is important is to find out what is it that you want from that situation, right? Going and knowing what your goals are and having clarity around that. But I think it's important to know what to look for to gain that clarity. And what I find is that not a lot of people that are going through the probate process or getting started, because let's be real here, this is not something that they deal with several times in their life, is it?
No, and it may be once, but it could happen again. Sometimes you run into situations where grandma dies and then mom dies like a year later. So sometimes they go through it multiple times. Sometimes it's just one time. I hear stories, oh, I was a PR one time. It was the worst experience I ever had. I don't know why. I don't know if it was the lawyer. I don't know if it was the situation. We have one right now where the PR, I guarantee, will never want to be a PR ever again because of how many beneficiaries there are. There were 10 or 11. So there are a lot of situations where there are contested beneficiaries and PRs, and it gets really crazy. But I love what you're saying about having a goal and a vision in mind, because a lot of people don't think about, they just dive in and they don't know where they want things to go. You either got to know if you want to just transfer it to everybody and then figure it out from there, or if you want to get, the property sold at top dollar. A lot of people don't think about the next steps, and there's always that period of time after the death where people aren't thinking about the taxes. They're not thinking about the mortgage. And a lot of times, I say this all the time, but the three things why somebody didn't pay their foreclosure, the mortgage that goes through foreclosure, or their taxes, they forgot, they can't, they're dead. So if they're dead, they can't pay it, and the heirs don't know what to do on the next step. And those are things you have to take care of. Otherwise, the bank will foreclose. They'll sell it at a public auction at a value that's a lot lower than a private sale. Thinking through those big pictures with the right lawyer matters. You would want to get the property sold faster in a reverse mortgage. A lot of people say in a reverse mortgage, if anybody doesn't know what the reverse mortgage is, somebody tapped the equity out of their home in order to get money. But as soon as they pass away, the bank then forecloses. So they got money because they didn't have any in their brokerage account. And then once they die, the heirs have a redemption period of 6 to 12 months. And then if they don't do anything there, then they foreclose. But the illusion of the reverse mortgage is they tell you, oh, just wait 6 months. Don't worry, you have time. Meanwhile, they are adding an interest of 28% every month. Yes, it's a lot. There's an interest rate that's really high. So
and who would that be? The bank, the lender, adding that interest?
Yeah. So we had that in Neptune Beach, where at the time of the passing, the property could have been sold for $500,000. The outstanding loan was $425,000, and so the heirs took their time. They said, "Oh, we need to get things out." I said, "You got to hurry up. You got to move out. The bank's going to keep adding interest." And they took their time. Meanwhile, the bank added about $70,000 of interest by the time we sold it 6 months later. So it's knowing the factors of the mortgage, the taxes, making sure you don't lose it to a tax deed sale. If you don't pay those taxes for 2 years and somebody has a tax lien on the property, you're going to be facing, that property's going to be facing a tax deed sale. It goes to public auction. The property's going to get sold for a lot less than if you list it at top dollar. So people don't think about these little nuances.
I got it. Well, you know, and I can't think of anyone that would know to look for all these things if they're going through it for the first time, right? And this is a time where you really want to align yourself with other professionals like a realtor and a good attorney to help you navigate that process and help you identify with clarity, what goals are there to be had, what would be realistic, what could we do to adjust to gain the most from that situation and help you attain your real estate goals. You deal with a lot of these on a daily basis.
Yes.
What are some of the recent stories that you could share with us without revealing anyone's personal information, of course, but you know, I think that we all learn a lot from stories. So if you could share some of the recent cases that you might have had that could help illustrate the process, I think that would be great, Al.
So I had one recently where I had a realtor investor have one. They said, we got to go through probate. So I got the family, they called me, they said, you know, let's sign up, let's do what we got to do. We got all the paperwork filled out that we needed. And I filed it in Clay County. And as soon as I filed it, it got kicked back to me. And they said, oh, there already was one open in 2003. And I said, what? You know, so I went through the whole work on a Saturday, I pounded it out, and then they tell me that. And so then I looked through the documents in the court file because it came up nowhere. I checked the clerk, we checked through the title underwriter, nobody saw this. And then we found it. I checked all the documents and saw that the property that we were trying to help get sold never was contemplated in the 2003 probate. So I had to reopen the old 2003 probate and then start appointing another personal representative to then ask the court to allow the sale to go through. And then 4 days later, we're good to go. So judge signs the order. We're going to close like in 2-3 weeks. So wow. The story behind that was, look at that. There was a probate from years ago, and it's just weird on my documents that I have to put 2003. You know, so, and then another scenario was in Nassau County. Guy died in November. The property with his wife was titled husband and wife. So it all went to wife. But all of a sudden, there was another property in Jacksonville she didn't know about. And he was the only one on the deed. So she then came to me. She said, there's a will. Because the county of residence is what matters where the probate is, not where the property is located, but where's the county of their residence.
So even if the property is in Duval County, but they lived in Nassau County, it would be the Nassau County taking over the probate?
Yes, the Nassau County would have the jurisdiction for the probate process. Okay. So we had to go into Nassau. We had to open up a probate, admit the will, get the property moved with the appointment of a PR to the heir. It was only one, but we got it done. We went to closing and got the property sold.
Wow.
Yeah, and I run into situations all of the time where, you know, it gets messy, gets sticky, you know, 1, 2, 3, 4 probates. Had another one in Clay. This one was my record time. I don't know how I did it, but it was record time. There was 4 heirs. They all had so it was titled as 1, 2, 3, and 4. This person was deceased. And when they died, they had no surviving spouse, but they had 4 children. And all 4 signed the contract. Everybody was good to go. And when everybody agreed, knocked it out, got it done in 1 day.
Wow, 1 day.
1 day.
You are a rock star, my friend. If anyone is going through probate or see probate coming to them in the future, this is the man that you need to be talking to. Please get in touch with Al. Now, this triggers all kinds of thoughts in my mind. My husband and I we own our home together, our homestead. God forbid anything happened to either one of us, because it's our homestead, it would not go through probate. Did I understand that correctly?
Check the deed. So if you or your husband are the only one on the deed,
yes,
and the one on the deed dies, yes, you have to go through probate. And if you have children, there's like an actual flow chart of what you get. So you may get a life estate, and that means you can't sell without the other two on the deed, on the remainderment, without signing on the contract. So homestead gets weird. You have to check the deeds. It all starts with title. I always tell people, before I do probate, before we get involved, I want to see the title commitment, because the title commitment is my bottom line. I love bottom line. And I want to know, or do we have to do 1, 2, 3, or none? And if we have to do none, that's okay. And I tell people, find the next one, right? So the title is huge. Going through the deed chain, finding out it went from A to B. This was a crazy one. We had one with A to B, B to C, D to E, E to F, and it missed right in the middle. And F thought she owned the property. Mm-hmm. And when we pulled a title commitment, it said that we needed to do a probate for C and D. There was a break in the chain. So in the world of probate, F never really owned the property. There was the break in the deed chain. So checking deeds is super important. Check that stuff. That's how you know where things start.
So on the deeds that I see typically when we do residential real estate transactions with a couple, a married couple, there's something like their name, last name, and name and last name, joint tenancy with right of survivorship. Okay, would that classification protect them from having to go through probate if anything happened to one or the other?
Yes. So if A and B are on title, and it says A and B with the rights of survivorship, joint tenants with the right of survivorship, I call that deed the survival of the fittest. They don't tell us that in law school, because that's not really what they classify it as. It's just the title thing. But the first one that dies loses, and then title goes to the other person. So if A and B, and then A dies, it all goes to B. It avoids probate.
Okay, and that's something that we see on the day of closing, and the deed is prepared by the title company. So it's important that if you don't know, to look for these things. Again, not everyone buys a home every single day. You know, the typical person buys a home every 5 or 7 years. And if it's been that long, you might not know to look for this, but it's important to work with a realtor that would know to look for that on the deed. How did the title company prepare that? Was it joint tenancy with right of survivorship? So God forbid if anything happened to one or the other, then you're not having to go through the probate process, but it would automatically transfer the interest onto the other spouse. Is that correct?
Yeah, with the recording of a death certificate and proof of that certificate, it then title in essence goes to B. But a lot of parents with children don't want to put their children as joint tenants with the right of survivorship. A lot of them want still the control to sell that property should they want to during their lifetime. And that's why a lot of parents with children like ladybird deeds, because you don't need the consent of the children if you ever wanted to sell, mortgage, convey, transfer. With the rights of survivorship, you would need those children plus you to sign the deeds.
Even if they're not listed on the deed, even if the children are not listed on the deed, would they still have to go through that?
No, what I'm going through is, like, let's say you created that deed to say parent and child as joint tenants with the right of survivorship, and parent wanted to sell during their lifetime. They couldn't do so without the child on that deed. Adult child, let's say that. Let's not go through minors right now, but that's a whole other ball game. Minors are completely different, but in the world of this real estate, let's just stick to the adults. So, but a lot of parents, in order to, if they wanted to sell, they like ladybird deeds, because the ladybird deed has language that says, I want it for my life, but with full power and authority to convey this property itself during my life and then to children. So it still gives them control. Joint tenants with the right of survivorship would require everybody to either sell that property, sign the contract. There's certain requirements.
Gotcha. Would that joint tenancy with right of survivorship would also protect them from going through probate if it's not their homestead? Let's say it's an investment property, not their primary residence, but something like a rental property, let's say. But the title on that is joint tenancy with right of survivorship. Would that also protect them from having to go through probate if something happened to either one of them?
Yes, it would. Same concept. If A and B are on title and it's the secondary investment property and A dies, it all goes to B. Same concept. A lot of people do it. I've seen it more and more recently.
And there was this very specific wording that you used for that. It's like all clad, super strong, something to that effect as to joint tenancy with right of survivorship. What was the wording you just used?
Which part? Survival of the fittest?
That was the survival of the fittest.
That's really the concept. If whoever dies first loses, their family loses. If you are a partner relationship buying property, it's like, whoever dies first gets it, right? That's the whole concept. But a lot of people like putting their properties in the LLCs, in whatever trust they have, just to make sure that their inheritance line gets what they want or deserve.
Fabulous, fabulous. Okay, well, I appreciate your knowledge. I appreciate you sharing with us. I'm very thankful that you're here joining me on the show. You're a repeat guest, and I hope that you come back again. Every time you come, you have golden nuggets full of great information that I really hope will benefit someone that is listening. A lot of my videos get watched on the replay. So if this is something that's coming to you now, great. If this is something that's coming to you a week from now, a month from now, or even a year from now, I want to go ahead and put Al's information on the screen so that way you can see how to get in touch with him. We work together in the sense that if you have a home or a property that needs to be sold that is likely going through probate, I can certainly help you through the listing side of getting that home sold, and he can help you with the probate process. So it sounds like in a situation like that, you're going to need a couple of experts, not just one, but we work together in combination to help you attain your real estate goals. Is there anything else that you'd like to share with us today?
And I'd like to just say that, the probate doesn't just simply apply to real estate. There may be people that, if friends, family members, somebody that died and didn't have a named beneficiary on their IRA, their brokerage account. And if there's nobody named, there needs to be a probate to make sure that the inheritance line gets the money transferred. All about title. So if somebody had $100,000 in the brokerage account for stocks and they didn't have a named beneficiary payable on death, you need to go through probate on that. But if you have a name, so friends, family members that have those issues, we had a bank account. There was somebody that had $30,000 still in there, no named payable on death beneficiary, probate. But you can avoid probate if you have a named beneficiary. That named beneficiary, in essence, takes over any will provision that says that somebody else is going to get it. It supersedes anything in a will. So having a named beneficiary on a bank account, Roth, IRA, those help avoid probate, but a lot of people don't do that. So there's real estate and then there's money, right? There's a lot of other things out there that a lot of people are not thinking about.
Yeah, and if you don't think about these things, that's when you get caught up in the whole process. So I hope that this is valuable information to you guys. If there's any questions, you can put those in the comments below. I appreciate you watching. Thank you so much for being here on the show. Al, stick with me for just a minute, okay? I'm just going to wrap up the video.
Okay.
All right, so there you guys have it. I hope that you appreciate this information. If you can benefit from it, fantastic. I'm so glad that it landed with you. But if this is something that you can share with anyone that could benefit from it, I'd appreciate you sharing that as well. And once again, my name is Angela Olmos. I'm a full-time real estate agent in the Northeast Florida area. I help buyers and sellers attain their real estate goals. And I look forward to meeting you and helping you through your journey of getting your real estate goals attained. So until next time, remember to be kind to one another. I'll talk to you guys very soon.